All right, team. So again, welcome to the webinar. My name is Diana. I'm joined here by Barry Habib and Dan Habib, who we all know and love, and by a very special guest, Jeffrey Love. He is principal of Price, Mees, Schulman, and D'Arminio attorneys and counselors, and he concentrates his practice in the areas of trust and estate planning, estate administration, and business succession. And of course, his bio goes on, but that's just a little bit about Jeff to introduce you. So thanks, Jeff, for being on with us today.
Thanks for having me.
Jeff, I wanted to share your wisdom and knowledge with our family of subscribers, because I know both Dan and I have learned so much from you, and I remember just there's so much that goes into trying to protect our assets that we don't think about. And in addition to that, we are in a position where we're talking to clients constantly, and it's important for us to help them create wealth, preserve wealth. And I thought that some of the tools or understandings of ways that people can preserve some of that wealth could be very meaningful, not only for the individuals listening for their own personal situation or those they know, but for them to also be able to help clients in looking at things in a way that they might not have thought of.
Excellent. Yep. And I can see already from the chat room, we have people from, Idaho and California and St. Louis and all over the place. So welcome. So yeah. So even though we live in a country with 50 states, there's a lot of really basic advice and planning, right? And at the heart of it, that's what we all do, Barry, right? You guys are mortgage professionals. You're advising people. You're helping people structure financial affairs, right? I always recommend to everyone I deal with is you always go to the source. I know what a mortgage is. I know assignments of rents and leases, but I'm not a mortgage professional. So if I need advice from a mortgage professional, I go to a mortgage professional. If you're structuring people's assets in a real estate transaction, title issues, right? There are issues of inheritance rights. There's issues of taxes. There's issues of liability. So it's fantastic advice, Barry, that when you're structuring a transaction of any nature, you always get the experts in to give you advice how to structure to protect yourself.
So Jeff, let's talk first of all, just if there are ways to help and protect the assets of individuals from let's just say estate taxes. Let's just start there with the basic premise, okay? So just give us a quick lay of the land on estate tax.
Great. It's a great time for estate taxation, right? So the federal government, when I started my career as a tax lawyer in the late 90s, you could only exempt about $1 million of assets from estate taxes. And if you had more than $1 million and you died, you were taxed at 55%. So great news is, as we sit here today, everyone on this call, no matter what state you live in, has a federal estate tax exemption of 13.61 million is the exact number. If you're married, it's almost $27 million of exemption from state estate taxes, or excuse me, federal estate taxes, right? So some great statistics were recently released. It's something like there's less than 5,000 taxable estates now in the United States, okay? What I want to advise everyone, though, is don't get lulled into thinking, well, that's permanent and that's forever, right? So right now we're in a period of very high exemptions for federal estate taxes, okay? I'm looking at all these little different states. We have to be very careful. Pennsylvania has an inheritance. New Jersey has an inheritance tax. Massachusetts has a state estate tax, okay? So it's a, don't get lulled into that if the federal government has estate tax exemptions that are really high, tax planning is not relevant. Okay.
What are they taxed on estate tax at ordinary income rates in the state?
It's a flat. So from the federal government's perspective, it's a flat 40% tax, right? So if you're a single person and you're fortunate enough to die with $20 million, you basically have about a $3 million federal estate tax, flat 40%.
But I'm talking from the state level.
So from the state level, for example, New Jersey repealed its estate tax, but it has what's called an inheritance tax. So if somebody in New Jersey transfers assets to someone who's not a family member, there's a 15% tax. Massachusetts starts taxing you if you have more than $1 million. So it's very, very state specific as to the rates.
So it can be pretty, it can be pretty meaningful given the low threshold that you have. I mean, if you own a home, there's a chance that you might be subject to in some of these states to have an estate tax concern, even if you are under the threshold on a federal level.
Yeah. And so, for example, I represent a lot of clients from New Jersey and the New York area that have, wonderful homes in Massachusetts, right? They have a $2-3 million property in Massachusetts. It's hundreds and hundreds of thousands of dollars of state estate tax.
So how do you go about sheltering that?
Okay, so from a tax planning standpoint, it's like anything. They built the pyramids with leverage. You're going to gift and use time as a leverage device, or you're going to try to give away assets before they appreciate in value, or you're going to give away assets on a discounted value. So the greatest advantage you have to avoid estate taxes is the government gives you a few exemptions. A lot of people hear that you have this annual exclusion. You could give anyone $18,000 a year, and that's exempt from estate taxes, right? And that should be done. So if you're in a situation where you're fortunate enough to be faced with an estate tax problem, you should get out ahead of this and use exemptions and time to transfer wealth.
So go ahead, Dan.
I was going to say, besides using things like the gift exemption,
Yep.
are there ways that you can mitigate this further with the use for your heirs of trusts and things of that nature?
Yes. So with very wealthy clients, what you have to watch out for is, if a client comes to me and they have $100 million and they pass away, they're going to get hit for about $32 million of estate taxes. If the child inherits 60 something million, well, they're going to get hit for 20 million of estate taxes. So trusts are an effective vehicle, Dan, where what you're doing is you're not just generally saying, okay, I'm going to be hit with a tax. Here you go, Dan. It's now your problem. So where you're using trusts is when gifts are made. And we initially started talking about protection, right? When you're transferring wealth, most people that have worked as hard as everybody on this call has worked, and if we accumulated wealth, we want to protect beneficiaries. We don't want to protect beneficiaries from, God forbid they get divorced, if they have a liability question. But the other advantage is if you could put assets into a trust, you can actually bless it with your tax exemptions that will avoid taxes when the next generations come along. So trusts are ridiculously important as a measure of protecting beneficiaries and avoiding taxes.
What are some of the negatives of putting it in a trust?
So great question. So a trust has a high level of income tax. Okay. So if you're talking, in the tens of millions and in the very, very large estates, because you're faced with such a high estate tax, income taxes become secondary. But let's assume you're a client, you have $2 million of taxes, you want to give it to a child in trust because you don't want it to pass to an in-law. You're worried that if that child dies, it goes to grandchildren. Okay. So a trust is very effective to provide that measure of protection. If estate taxes are not needed, trusts are administratively complex. They require income tax returns. If they require trustees to account to beneficiaries. So if you have potential disputes among beneficiaries, and they also could carry a high level of income tax. So for example, everyone on this call, if you're an individual, you have to make about $250,000 to pay a high level of income tax. A trust gets to the highest level of income tax if it only makes about $12,000. So income tax planning, administration, and also managing the beneficiaries if there are multiple different split interests.
Could you give us some thoughts on, while it might be different from everyone, it might be different from
Yep.
state, what level of assets or income should someone really start thinking about this? I'm talking for the people that are on this
Yeah.
call. Where should they really start saying, hey, I need this needs to be part of my planning?
Everybody. So we'll start with, against the backdrop that, when I go to cocktail parties, if I go out to dinner and people say, okay, I do trust and estates, everybody on the planet says, I need this. Everybody goes to the solution, right? So at its primary heart, everyone needs estate planning, even if you don't have a tax problem, right? Because what estate planning does, and there's really two aspects of estate planning. There's lifetime planning, right? So I'm a partner in a law firm. I have an interest in a law firm, right? I have assets of my own. My wife has assets of her own. If I become incapacitated and can't handle my affairs, I need some kind of planning to put documents in place to make sure my ultimate wishes are fulfilled. or that my interests are protected. So regardless of a tax question, everyone, regardless of the state you live in, I would have your lifetime planning in order. Who handles my affairs? Who helps me make medical decisions? Now, many of us have very simple lives, right? We might have, I'm single. I have a wife for 30 years. Others might say, well, wait a minute, I have a split family. If I have a will that goes among a split family and I lose my faculties, if I don't have a good power of attorney in place, can my plan be thwarted? So quite frankly, regardless of tax issues, from a lifetime standpoint, everybody should have their affairs in order for protection, financially and medically, if something happens to them. Okay. Now, when they pass away, even if you don't have a tax problem. So I had two people call me today. One had $13 million that lived in the state of New Jersey and was all passing to children. The tax on that case is zero. This woman could say, I'm giving everything to my children in trust. Everything's protected, no problems, right? So that she should have a will that really doesn't address, or a trust. Different states have different probate rules, but what you're trying to do is be very efficient and make sure that in the case where there's no taxes, that the children who receive that 13 million receive it in a protective fashion, right? And everybody's unique. You might have grandchildren with special needs. You might have a child that's going through a divorce. You might have a child who's a doctor that you're worried about getting them sued. So everybody on this call, when you're talking about estate planning, if taxation is such a small issue to a large percent of the population, protecting your beneficiaries or make sure your testamentary plan is implemented absolutely applies to everyone on this call. Same about 2 hours ago, I got a call from a wonderful family that, they came out of Hudson County. They worked their tails off. They were able to have a house and a shore house. They had $4 million estate, no children, no spouses. That woman is facing a $600,000 New Jersey inheritance tax if she dies. So it's kind of funny, but that's a tax case. The other case really is not a tax case. So without question, everyone should have powers of attorney and a testamentary plan with the advice of qualified counsel to make sure your wishes are fulfilled.
And there's some questions coming in here.
Sure.
I see it says, for inheritance tax, is it paid in the state where the beneficiary resides or where the individual resides?
Great question. So most inheritance, so New Jersey's inheritance tax, Pennsylvania, is based upon the domicile, the residence of the decedent, not the beneficiary. Okay, so that's an inheritance tax.
Okay, so but that could be different in every state, right?
Yeah, but most only, so you only have a constitutional basis. A state only has a constitutional basis to impose a tax if it has property in the state or there's a resident. So that would not change. So it really is not based upon the domicile of the beneficiary. It's the decedent or the location of land.
Understood.
Okay.
Now, let's talk a little bit about if you've accumulated, let's just in the tens of millions, but I think most of the people on this call have accumulated, homes and assets and some savings and retirement plans. How are retirement plans dealt with in an estate? Is there any special treatment for those?
No. So sadly, if you're in an estate tax paying situation, you're paying an estate tax on the gross, notwithstanding the fact that the beneficiary is actually going to have to pay income tax when that plan is ultimately distributed. Okay, so like any other asset, your home, your investment accounts, an IRA could be subject to estate taxes. Okay, the real planning situation, and that's a really, I'm going to say, a sophisticated income tax question, right? Because most people like the concept of deferred income taxation, right? We all put in money in our retirement plans, we get a tax deduction up front, and it grows tax deferred. In a planning mode, you have to look at it to say, well, if I die, my beneficiaries have to take that money out over 10 years. So there's always going to be a tax hit. So when you look at the concept of planning, you have to look at it and say, if I'm in the highest tax rate, if my children are in the highest tax rates, we should basically do some kind of math and say, is it more economical to take that plan down and invest the assets? So if they grow, we could, and we're not in an estate tax paying situation, we could avoid taxes. Okay.
So, Jeff, let's
Sure.
talk for a minute about one of the tools that could be used in estate planning, which is life insurance.
Yep, exactly.
And I think that probably of the, I don't know, 450 people on this call, many of them probably have some form of life insurance. But isn't it critically important the way you buy your life insurance, and shouldn't it go into your estate tax plan? Because if you have a policy that pays off X amount, couldn't that trigger an estate tax within your state?
Yeah, great question, right? So life insurance, a lot of people have strong opinions about it. I don't. I think it's a very effective asset class, right? You know, everybody on this call, we have investments, we have business interests, we have retirement plans, we have stock investments, we might have real estate. But life insurance in an estate planning context is an asset class, right? So most people look at life insurance to say, well, I'm a young individual. I might have beneficiaries that need a death benefit. So that's one component of life insurance, that you say, I'm going to pay for somebody's college. I'm going to pay off a house. There's going to be some survivor income. But many of my very sophisticated clients look at life insurance as an asset class. So you are correct, but you have to be very, very cautious of. And I want to make one observation. It's 2024. At the end of 2025, our estate tax laws are set to sunset. Right? So the way that our laws work is the law that was enacted that raised these tax exemptions really high was enacted 10 years ago. And we have sunset rules to say you can't have laws that go out that long that affect the budget. So we have a law that basically says at the end of 2025, that estate tax exemption may go down to $6 million per person. And to your point, Barry, is if I'm an individual and I have $5 million of assets and a $3 million life insurance policy, that life insurance policy, if I own it and I control it, could contribute to estate taxes, even though it will be received income tax free. I mean, it would be an absolute insult to say I have $3 million to protect my family and I owe 40% of estate taxes on that death benefit. So that's why many of our clients will say they want to buy a permanent life insurance policy in a trust because of a few things. You could get a very high death benefit for a smaller premium. And if it's owned by a trust, it's not subject to estate tax.
So if you are going to choose a trust, just to kind of go back to that, the benefit of putting it in a trust is that you're getting the value of what it goes in the trust the day you put it in. And do you
Correct.
then experience the growth of it essentially gets included in your sheltering from estate taxes?
Exactly. Right. Yeah.
Okay, let's look at an example. So
Sure.
let's just say if we'll pick something like NVIDIA. I picked the NVIDIA stock, which has taken a moonshot,
There you go.
right?
Yeah.
So if someone bought NVIDIA stock that they thought was going to go to the moon, and they put $1 million of NVIDIA stock in a trust,
Correct.
then it used up $1 million of their exemption, right?
That's correct.
So the current exemption for an individual is 13 million roughly?
13.61. Yes.
13.61. So I used up just $1 million of that NVIDIA stock, but since it's gone up, you know, eightfold or something like that, so now it's worth 8 million.
Correct.
That whole 8 million is sheltered.
And if you put it into a trust, what I would have done is filed a gift tax return and not only sheltered it from estate taxes when you die, if that stayed in a perpetual trust and went to Dan, it wouldn't be subject to estate taxes when Dan died if he kept it in there. So yeah, so the benefit of a trust is sheltering it from these transfer taxes.
So now I've got my money in a trust, or someone's received an inheritance in a trust.
Correct.
Okay, how do they get it out?
So it's an easy conversation that you have with beneficiaries. So let's just take that example, right? So take that example as you had 10 million in your estate and 8 million. So you had one child that inherited an $8 million trust and had $10 million of assets, right? So the conversation, and that's why it's planning, it's not a document or a fix. The conversation you're going to have with that child is, okay, child, first easiest question I'm ever going to ask you. You have an $8 million trust that's going to stay outside the tax system, and you have $10 million that's in a tax system. Which one are you going to protect and preserve, and which one are you going to use, right? So what you've done by being vigilant and being proactive is you've really teed up your children's future, because they have one bucket that's never going to be subject to estate taxes, but it could be used, right? And you have another bucket.
How do you use it?
So, for example, all trusts are written very flexibly. So that trust would be written is that after I'm gone, the $8 million is available. Many times they're bloodline trusts. It's for your descendants, it's for your children, it's for your grandchildren. And there are very flexible mechanisms to say the principal and income of that trust can be used for health maintenance and support, or for any reason to benefit those beneficiaries. Okay.
Could you use it? Could you use it to buy cars or homes?
Everything. Yes. Yeah.
So there are ways that you can get that money out of the trust and make it part of what you're doing.
Absolutely. And in many instances, they are. They're used. So let's assume you had that $8 million trust and you had a child that legitimately had no money, no income, no assets, and they needed it. The trust would be absolutely positively used to provide for all of the expenses, the care, and the support of that child. Absolutely.
So could it make their mortgage payments? Could it make their...
Yeah, and in instances where I'm a trustee, and then, sadly, where you might have people that have, horrific drug problems, or they might have spendthrift issues. So in many instances, those trusts are set up to say, okay, look, the home is going to be owned by this trust. The assets are going to be owned by the trust. We are going to pay all the bills out of this trust. So we're not just, distributing money to you.
Including any down payment on the home or something like
everything.
that? Okay.
So I have trusts that own, paintings and build anything any human being can own, a trust can own.
So I have a question. So let's say, to use the other example, right? So you put NVIDIA, like $1 million of it in there. That used up the $1 million of an exemption.
Yeah.
It went up to, to 9 million. You gained like 8 million in it, right? So you said that was like protected. Now it goes, that individual passes away. It goes to the child. Now, if they want to take that NVIDIA stock and do whatever they like with it, right? They have the ability to do so. And then are they taxed at any type of capital gain from, the stock at any point there?
Fantastic question. So if the parent took $1 million worth of stock that they bought for $1 million and put it into a trust, and it grows to 9 million and stays in the trust, we've avoided estate taxes, right? We've kicked the income tax issue down the line. You don't get a free pass on income taxes. So income tax avoidance becomes very, very important. So many really sophisticated financial advisors say, listen, we don't want all our eggs in one basket. We have to get into tax loss harvesting. We have to get into hedging strategies to sanitize that gain. Okay, that's one way to do it. In my world, there are ways that we could keep the money in trust so it goes to grandchildren, but if we treat it as being owned by the child, and God forbid the child dies, there's rules called steps up in basis where we could consider it an asset of the child and actually wipe out that capital gain. So it really is a combination of working with accountants and sophisticated tax lawyers and an investment advisor to basically look at income taxes in a trust. So the really big ones, you would say, great, I have a child, I have 3 grandchildren, right? The child doesn't need the money, the child's in a really high income tax bracket. Let's split this trust, divide it among the grandchildren. The grandchildren don't make any money. Let's pick up income at the grandchild's level. So a trust is a vessel or a vehicle that starts to avoid estate taxes or starts to protect money, but then it just gives the beneficiaries the freedom and the flexibility to make those choices and do their own plan.
I see a question here. Does your trust need to be changed from a revocable / non-revocable type to another type of trust that continues on post-demise of original trustees? I was under the impression your trust must be closed once all distributions have occurred.
So that's a great question, and I'll there's a few concepts. Okay, so in many states, I see with lots of people in different states, probate is really, really difficult. It's court supervised, it's expensive. So many people use this concept of a revocable trust. So let's say I have a house. Let's say I live in Florida, but my children are in New Jersey, and I have a house and a couple investments. I would use a revocable trust as a vehicle and put all my assets in it. And the reason that I'm doing that is to avoid probate. It's still my money when I'm alive. I haven't avoided estate taxes because I haven't given anything away, but it's revocable when I'm alive. So if I pass away, that trust becomes irrevocable. My children can obtain control, and then it's not an estate tax issue. It's a probate avoidance issue. Now, the trust becomes irrevocable, and let's assume I had $2 million in it, and I say, listen, trusts are too complicated. I want the $2 million to go to my child. If the trust read that at my death, the assets go to my child, that trust would be over and it wouldn't continue, right? My oldest child is a lawyer. If I say, well, instead of it ending at my life, what I would like to do is I'd like him to have a continuing trust so that if he holds the money in the trust and he gets sued by one of his clients or he gets divorced, the money stays within the family, then I would have a continuing trust. So you have the option whether to extend trusts or not, or to just distribute them at a certain time.
Can you tell us a little bit about the annual exclusion, because that's kind of in addition to the lifetime exclusion, right? That you get.
Exactly right. So
and I think that I think that it's something that's under you, in my humble opinion. Obviously, gazillion times better, but
I can't agree more.
Okay, yeah, I think it's underused, right? And I think it's because it's underused because maybe people don't know about it, but it could be a big help, because that's a real way to transfer a significant amount of money tax free. Am I right?
And it resets every year, right? So if you take a married couple, they have
just explain, outline it for everybody, Jeff, to explain what it is.
Sure. So the government allows you to give away $18,000 to as many people as you want during a calendar year, and you don't really necessarily even have to report it, and it's an option to avoid estate taxes. So let's say,
wait a minute, $18,000 a year to anyone?
Anyone.
And as many as you'd like.
So let me get cute here. Okay.
Yeah.
Okay. So I've got someone who comes in that's a cleaning person.
Yep.
Okay. But I want to give them, whatever, $1,500 a month. I could actually do that and it's tax free.
If it's a gift and you're not trying to avoid.
If it's a gift. If I could give it to him if I categorize it as a gift.
Yeah, I think the most I have one client that probably gives away 150 $18,000 gifts a year.
Wow.
It's not limited to children. It's any person, and it resets every year. So most people, if you're married, it's 18 times 2, it's 36. So if you have 3 children and 7 grandchildren, you could give away $360,000 per year free, and it resets every January.
And it's not taxable to either the recipient, and it's not taxable to me, right?
It does. Yes, there's no gift tax by the donor, the transferor, and the recipient. The best thing in the world to be is the recipient of a gift. You get it tax free.
Wow. And Dan, I know you've been watching the questions, so
yep.
We only got about 10, 15 minutes left. So
yep.
Dan, knock out some of those questions quick if we can.
Sure.
By the way, Jeff, this is awesome.
Anytime. You guys are great. Yeah.
Let's see. John Leach is asking, for a person that has just purchased their home, just started to create assets, savings, investments, 401k, IRA, where's a good starting point for them?
So I'm going to start.
By the way, Dan, go back to some of the other ones too, because there was some that were repeated too. So just go back.
Okay.
Go ahead. Jeff.
So let's start with that one, right? So what I would say, okay, I don't know, are you married or you single, right? So you have a home. It's a great investment. It's a great opportunity. It's yours, right? So what I would probe you was to say, okay, what happens if something happens to you, right? Is it going to your family? Is it, do you have, what do you want to happen with the asset? Who's handling the asset? So the first thing you would talk to somebody about is if they're single, who's going to manage the asset? Who's going to inherit the asset? If they're married, right? Or if they're cohabitating, at any time anyone comes into me, I'm more like a physician than I am a lawyer. It's like, okay, let's take your symptoms. Is someone going to get an occupancy right? Did you buy this thing before you got married? Did you buy it and then get married? So in each particular instance, the questions are always the same. what's going to happen to this? How should it be owned? And how are we going to protect it for the people who need to inherit it? Right. So it's a function of when you take title to the home, if it's you individually, you take title to the home. If you're cohabitating, is someone going to own it jointly? Is somebody going to own it as a tenant in common interest? So you always should get competent advice as to how you structure your affairs.
All right, we're going to try and go lightning round here if we can.
No problem. Yep.
Permanent or whole life?
So I have a client who's 82 years old and he's got a gazillion dollar estate tax and he's got term insurance and it's all expiring when he's 90. So I always joke, I say, you're going to have a food taster when you're on your 89th birthday, because, if that stuff expires, it's not going to be used to pay estate tax. So if you have a permanent need, use permanent insurance. If you have a temporary need, use term.
Dan, go ahead.
So, when you're putting things in an estate, like let's say you have, let's say somebody in this call, they have a couple kids, they put like a living will together, they have a trust, and they have like a couple pieces of real estate property that they put in it, but these aren't completely paid off, right? So so this goes into their trust, and now it passes along to the kids, but the trust still has to be making the payments on all of these different things, right? So they could be in a position where the kids may not be, this is where you would want to supplement this with different things like life insurance to want to make sure that they can meet those financial commitments of the things that they're leaving to them.
Fantastic point, because I don't do what I do in a vacuum. I create the legal protections. I avoid the fights. I always say, okay, in that situation, let's say there were children from a prior marriage and these things are subject to mortgages and you gave everything else to your second wife. I always tell people to ask business questions about your personal affairs. It's like, who's paying the mortgages, right? So to your point, is if the wife's getting everything else, yes, you need to put life insurance or something in there to allow that equity to be preserved, right? So I think everybody just has this false sense that as lawyers, we have this rule book and we know we know lots of rules. There's lots of technicalities, but the real advice is your affairs have to be personally structured.
Got it. So some quick ones here. So quick. Is there a max recipient beneficiary of the gift has lifetime?
No.
Okay. If you're gifting to a child who is an heir to the trust, can you send $18,000 gift to a B trust that is assigned to that child that is still part of your original trust as a subtrust?
It's $18,000 per person. Okay, so meaning you can't say it's I got 18 in this share and 18 in this share. You can. There's a case. There was a great case called Cristofani, which is, let's say you have 3 children, but you have like 7 grandchildren and 2 great grandchildren. You could literally say, well, wait a minute, even though the kids are going to get this, if all these people die, there's all these remote takers. And I think there's one family tried to take the position. There was like 116 remote takers. So they tried to take advantage of 18,000. But you can't use one person twice. You could use successive generations.
What happens when you go over the $18,000 gift? How much will they be taxed? I would imagine ordinary income.
Zero. No, zero. No. So remember, the recipient, Barry, you cut me a check today for $5 million. I would high five you, and I've got $5 million tax free. I pay 0. Okay. You, from your side of the ledger, would say, I was allowed to give Jeff 18, and 4.982 million comes off my lifetime exemption. So you pay 0. But you have that much less you could shield for your family, and I am a happy camper.
Understood. So it's when you go over the lifetime exemption, which currently individual 13.61, double that for married. But remember, it's a moving target because in a couple of short years, that reverts back to 5 million, correct?
Couldn't say it any better. Yep.
Okay. All right, Dan, any other questions? I'm trying to look at these quick.
I saw a couple people ask about a retirement account. Can that be in the name of a trust, or would you just make the beneficiary the trust?
Fantastic question. So those assets are not transferable when you're alive. So if you have a $10 million IRA, you can't say, no, I want to give 50% away. Okay. So you can't, the only legal authority to transfer a retirement account is pursuant to a state divorce judgment. But yes, you can say, well, wait a minute, I have a $10 million IRA. I have a child that has spending issues. I want to flow that through a trust, the benefit.
Right. And hey, I would be remiss to say, guys, I want to just tell you, everybody, full disclosure, So Jeff is my estate planning attorney. I mean, I love Jeff. I think he's brilliant, but what the greatest thing about it, maybe it's coming through here, is not only is he brilliant and has extensive knowledge, but it's very easy to work with. Like, he explains stuff, he goes through the variables. It's like, for me, this was probably, my estate is relatively complex, but Jeff just has a way of just making it easy. And that's why I wanted to make sure that he shared some of these ideas with you. But Jeff, listen, I just want to throw it out there.
Sure.
If somebody wanted to get in touch with you, whether it's to work with you or ask you or whatever, how would they best do that?
Probably, email is the best, or email is the best, right? Jeffrey, I'll send it to you. You guys have it. The easiest way.
Yeah,
Is,
put it in the
I'll
put it
put
in
it
the
in the
chat real
chat.
quick.
yeah.
Just put it in there for everybody.
Yeah.
Diana, always Johnny on the spot.
Call
By the
Barry.
Jeff, question for you.
Sure.
Are you limited to where you could take clients on?
So I'm licensed in New Jersey. I am licensed in New York. We have staff that's licensed in Florida. For example, I just recently got clients out of San Francisco or the West. I'm allowed to deal with the federal estate tax for anybody, right? Because that's a national thing. But there are many instances that I'm smart enough to realize if I go out of my state, I always want local counsel assistant. I don't know everything constantly. So in many instances, I have clients that move here, they move to Utah, they move to Montana. I could handle matters, but I would have to get local counsel.
Yeah, guys, I just want you to know that this is an important issue. I'm so glad you're on this call, because it's an important issue for all of us, whether it's a dollar issue or whether it's, I want my wishes to be fulfilled. I have seen it too many times, just like you probably have as a mortgage originator, where it comes up, it gets confusing. It's just great to have somebody in your corner that is just protecting your wishes and your dollars that you work so hard for. Because the estate tax, it's if obviously the state one by state is important, but the federal one is it can be very punitive to you if you do exceed those levels. And it might be easier than you think to exceed them if the law does not extend. If it gets sunset to you can get to 5 million. It's not that crazy to get to 5 million if you own a few pieces of real estate and appreciation and have an interest in the business.
Do we have a couple minutes? I'll
Yes.
rattle. So here. So I always tell people it's what you don't know that bites you in the tail. Right? So I always tell people, if you want to work with really great I don't know the first thing about a mortgage. And I'm not embarrassed to say that. Like, if somebody asks me to give advice as a lawyer, I know what a mortgage is. I know what collateral is. I know aspects of it, but you always got to go to the source. So one of the seminars I gave recently was, because the tax exemptions are so high in my own firm, you have a lot of people say, I could do wills, I could do trusts, I don't have to worry about taxes. What I've learned, and I'm saying from debacles over 35 years of being a lawyer, is, you have marital inheritance rights, you have divorce issues, you have business disputes, right? So you always have to go to somebody that gives proper advice, right? Now, I've seen so many people, and this is my hit list with me and one of my associates just went through the stuff that comes through our door where people are already dead and never got advice, right? Intestacy. I can't tell you in the last 2 years how many people, I never met the people, came in here and they had no wills, right? Please have a will. Right? I have cases where somebody dies without a will. They had a child 40 years ago that they haven't seen, and that child gets a piece of an estate. They're absolute debacles, right? So please, if anybody, you're working with people or yourself, please have a will or a trust, right? Outright distributions to children, right? If we're talking about mortgages and we're advisors and we're professionals and we're dealing with people that have an investment like a house, right? Most people that have worked that hard for money, when they give their money to their children, there's no law that says, here you go, good luck, right? So even though children are grown, there's a real benefit. And I think the detriments are outweighed by making sure that assets stay in trust for children to protect their own inheritances, okay? Lawyers copy wills that have no idea what they were doing. A few short years ago, the federal estate tax exemption was 3.5 million. The gift exemption was $1 million. I get people coming to me with wills that are 15 years old that have references to laws that were repealed, right? get a fresh look at documents, because most people don't even know what they say, including the lawyers. Um, Elective shares for spouses, right? If you're getting separated or divorced, right? Many people say, well, yeah, my wife is my agent under a power of attorney, or my wife is my beneficiary. When people are getting separated or divorced, do you want your spouse or soon to be ex-spouse being able to handle your affairs? I mean, do you want your spouse to inherit your entire estate? Now, there's no answer to that question. COVID was horrible. I had 3 men came in here that the wives were divorcing them, and they didn't want to be divorced. So they delayed the proceeding for years. But the rights that they have to either include their wife or exclude their wife are subject to marital inheritance laws, right? So you really need to know what you're doing when you're addressing these issues. Non-citizens, there's really complicated rules about non-citizens, right? So you have to understand all these rules. And I could just go
No, this is Jeff. This is gold. I mean, it's gold.
It's
Jeff, as always, you're incredible. So many people are asking you, can you recommend somebody in South Carolina and Massachusetts or Maine, whatever? But what I'd suggest is you have Jeff's email. From a federal level, he can help anyone. He is a prince to work with. If you have a specific issue for the state, Jeff will make the recommendation to you. But I have I've got a few years under my belt, but I've never found someone that can take this topic and make it as easy to get through some of these uncomfortable circumstances, or that helps me think through it in a way that's fair, that contemplates everything, Jeff, you think of things, you've taught me things I would have never thought could have come into consideration. And I think that you've positioned me very, very well. So I just want to make sure I shared that with everyone. I appreciate you, Jeff. You've been so helpful. I mean, people are loving you. You're getting all this love. I hope you see it.
Yeah.
Stuff that's coming on there.
I think it's my first time on camera. I'm not used to this. You guys are used to it.
Yeah, we appreciate you, Jeff. It is you're getting definitely the love from everyone here.
Awesome.
It has been wonderful. Dan, I'll let you guys.
I love that one. Am I on social media?
Dan, Diana,
I think so.
Final comments from you guys?
No, thank you, Jeff. You look very handsome, by the way, on
Yeah.
camera. But
I just winged it. I should prepare for the next one. This is just kind of what came across my desk in the last week.
You got one comment from Craig saying you need your own show, brother. God bless you.
Yeah, I can't sing or maybe I'll be in Rock of Ages or something with you. Yeah. Thanks, everybody. We're good.
Thank you.
We are good.
Anybody just call me if you need me. God bless everyone.
Thank you. We love our MBS Highway family. Thank you, everyone.
Thank you, everybody.
Take care, guys.